Going through a divorce in Maryland can have a lot of legal ramifications. Maryland Legal Aid provides legal assistance to low-income and underserved Marylanders in many areas, including family law. Makita Kirby from Maryland Legal Aid begins the discussion by discussing the different types of divorces.
So some important information to know about divorce in Maryland is that there are two types of divorces. Absolute divorce, which is a complete termination of your marital rights, and a limited divorce, which is a divorce proceeding that does not terminate your marital status but addresses some big issues. In absolute divorce cases, you do need grounds for a divorce. If you do have grounds for divorce, the court can address issues such as marital property, alimony, marital debt, child custody, and child support issues as well. There are approximately 8 grounds for divorce in Maryland, which includes mutual consent, a 12-month separation, adultery, criminal conviction, excessively cruel and vicious conduct, as well as some other grounds. More commonly, the 12-month separation is the most common ground.
For couples with children, divorce can get even more complicated.
Every family is different, and custody can be a huge issue when families divide. There are 2 types of custody in Maryland, and that is physical custody, and that is where the children live and who provides the supervision for children, and legal custody. And legal custody is the ability to make decisions on behalf of your children. And there is not a one-size-fits-all custody arrangement, as every family is different. In making a custody determination, the courts will look at the totality of the circumstances and consider the best interest of the children in that case.
For those who are suffering from domestic violence, help is available from Maryland Legal Aid.
Domestic violence is definitely a traumatic experience to go through, and I would just want survivors to know that you are not alone, that there are plenty of resources, including Maryland Legal Aid, House of Ruth, that are available that can assist in guiding you through the process. We do understand it's a trying and emotional time, and you may not know the best recourse. My other advice is to report it. Oftentimes, a lot of these situations go unreported and continue to proceed without any kind of recourse. It's always important to contact law enforcement if you're in immediate danger, and definitely reach out for help. And Maryland Legal Aid is definitely a place you can contact to get pointed in the right direction and additional assistance.
Makita leads us through some of the steps available to those people concerned with domestic violence.
A person who was subjected to domestic violence should file for what is called a protective order. A protective order is a court order that will prevent the abuser to continue to further abuse the petitioner. One important thing to know is that if the courts are closed, a victim or survivor would be able to go to a commissioner's office to file for what is called an interim protective order. An interim protective order typically lasts until the next business day that the court is open. In order to get a protective order, you need to be a person eligible for relief. And typically, to be eligible for relief, there has to be some kind of familiar relationship. And that relationship could be by blood, by marriage, or adoption. And there are some other provisions as far as seeking a protective order for a child or an elder adult. Once you go for the protective order, you will likely be granted a temporary protective order. A temporary protective order is valid for 7 days. The temporary protective order will grant the petitioner relief that the abuser should not contact, harass, further abuse the petitioner. The other thing to know about protective orders is that not only must you be a person eligible for relief, you also must be subjected to abuse under the statute. And some forms of abuse could be physical violence, threats, assaults, harassment, stalking. And if the court does find there are grounds for a protective order, they will grant a temporary protective order. The abuser would then have to be served with the temporary protective order, and the court will set the case in for a final protective order hearing. If the final protective order is granted, the final protective order will be valid for a period of up to a year. In regards to the blood relationship, it could be as simple as some kind of biological relationship, meaning that it could be a child that you're filing against, could be a parent, could be a sibling, could be a cousin. In circumstances where parties have children in common, that is also covered under the statute. So if the alleged abuser is the other child's parent, you can file an action against them and it can be granted. Additionally, you are able to file on behalf of children who may have been subjected to abuse, as well as elder adults that may be subjected to abuse.
For more information about Maryland Legal Aid, visit their website at mdlab.org. You can also visit the Maryland Courts website at mdcourts.gov for more information on these topics today.